And as soon as the gavel fell, he hit a switch somewhere in the universe, and that painting shredded all the way out. Now, here's the thing. Now that that painting is shredded and is still in the frame, it's probably worth more than 1.6 million, because not only do you have the painting, you have the performance. So performance art probably raise the value of that painting, and what they'll do is they'll put the whole thing in a frame and fill it by nitrogen, and then they can sell it.
It's not like halfway through, so it's still in the frame.
It's still in that frame?
It didn't shred all the way. We're like,
Okay, so we'll take the whole thing. We'll take the whole thing the way it is now, just the way it is, and we'll frame that whole thing just the way it is now, and it'll probably be more valuable than it was before.
He did that on purpose.
He did. Yes, he did. We know that, because he's a really interesting artist. He does a lot of stuff on walls in various cities that the cities will pay him to do, and it's just remarkable. So an auction with reserve is where the seller merely expresses the intent to receive offers, and then the auctioneer represents the seller. He can withdraw that item if he doesn't think that the price is good enough that he's getting. And we say he does that before the hammer falls, and that's, the gavel comes down and strikes. Before the hammer falls, signaling acceptance of the offer, the bidder or offerer may revoke the bid as well. So the auctioneer or the bidder / offerer or offerer may revoke that bid before the hammer falls. So the person who's actually put that object up, so if Banksy put that up and decided to withdraw it, he could have withdrawn it before the hammer fell. The bidder, who was offering $1.6 million for it, could have withdrawn the bid. Or the auctioneer could have withdrawn the bid. But Banksy wasn't going to withdraw that bid because he knew what was going to happen. And that was a really cool thing. I watched that and I went, "You're kidding." And my wife pulled it up on her phone and showed it to me, and there it went. Just got shredded halfway down, but not all the way, because it was the performance part of it that added the extra value to it. Okay, so that was an auction with reserve. An auction without reserve, the seller has to accept the highest bid. It goes to whoever made the highest bid. That's it. That's the whole thing right there. And that's what makes auctions kind of fun, because you never know. It's like being in a financial word fight. You just have to get everything in and do it the right way. Communication of acceptance. We talked about unilateral contracts. You don't have to have communication in a unilateral contract because the person's going to show up and do it. In a bilateral contract, communication is necessary. So there has to be acceptance of a promise, and the contract is formed when the promise is made and returned. Other times when communication isn't necessary are if the offerer says you don't have to do it, or if silence is agreeable as acceptance, which we said doesn't happen very often. The person will say, "You don't have to say anything now, just show up in the morning and start on it," which would be a unilateral contract. And the person on the way out says, "Okay, see you in the morning." Rarely do we have complete silence. The mailbox rule. This is where I was talking about the contract being put in the mail to someone and then the acceptance being returned by fax. The mailbox rule it's an old time thing, and it was done because mail was really slow. This was back when they had horse and buggy mail delivery. Acceptance by mail is effective when placed in the mailbox. This is an old time rule. It doesn't really work that way anymore. It's the speed that's important now. However, revocation of the offer is effective only when received by the offeree. So if I accept it, it's good when I put it in the mailbox and mail it. But If I want to revoke that offer, I have to do it before that acceptance gets to the person. So I have to do it faster. So if I put it in the mailbox and I realize, oh, I really don't want to do this, then I have to put on my PF Flyer tennis shoes and go running off downtown and say, no, 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 here's a written revocation. So we have to do it faster. So revocation has to be done faster because it's only good when it's received. Okay? Here's some ways contracts are rescinded. Well, revocation, they can be revoked anytime before they're accepted. Two parties can say, no, we don't want to do this. And it's revoked. It can be done in writing. If the contract is in writing, it has to be done in writing. If it's an oral contract, then it can be done orally or in writing. The revocation is effective when it's received. It can be express or implied. And revocation of an offer to the public has to be communicated in the same way in which the offer was communicated. So by chance, if there's an advertisement that actually is an offer to the public, and the retailer suddenly realizes that it took the form of an offer, they have to revoke it in exactly the same way, immediately, faster, right now. Okay? But it has to be done in the same way in which the offer was communicated. If it was on television, the revocation has to be on television. If it was on the radio, it has to be revoked on the radio. If it was on the internet, it has to be revoked on the internet. You get the drift. Termination of an offer can be by rejecting the offer, by making a counter offer. Oh, what's that? Let's say I'm buying a piece of property.
Down payment.
Not quite, we haven't gotten to that yet. I'm buying a piece of property, and I offered to buy that property for $150,000. The seller comes back to me and says $150,000 isn't enough. And they say, we think you ought to pay us $200,000. They have counter-offered and by offering me the property for an additional $50,000. You're already shaking your head. It's just an imaginary piece of property. I mean, you know, it's...
I mean, I know it's like 155, but that's like, you know.
Okay. You sound like a budding real estate agent to me. So, you can reject the offer outright, or you can counter-offer that way by making an offer back to the people who made the original offer of purchase. The death or incapacity of the offerer. In other words, if the offerer is adjudged incompetent by a judge, then the offer automatically terminates. Because we then know that the individual was not of mental capacity to do it. No legal capacity. Death. Offers are not ambulatory. Ambulatory means they do not walk on their own. They have to have someone carry them. So if they are ambulatory and a person dies, they are no longer ambulatory because the person who made that offer no longer can carry the offer forward. That makes the offer terminated. Destruction of the subject matter of the offer. There was a violin, a Stradivarius violin, very, very famous and old violin, which was held in someone's personal collection. They were going to sell it to another individual. The violin was put on the aircraft in a padded case, but when they got it to its destination, off the airplane, it was shattered. That kind of thing always makes me sick, because those things are objects of art, and they're beautiful in their own right. So it was destroyed somewhere between the airplane and the delivery. That terminates the offer because the violin no longer exists. Subsequent illegality of the subject matter of the offer. These days, people are creating IPOs and contracts for the sale of cannabis, which in some places is legal, in some places it is not. If it is legal, and we'll say this is Colorado, it is legal in Colorado. But what happens if all of a sudden someone has made an offer for a cannabis store, complete with its inventory, and the authorities in Colorado decide that it's not going to be legal anymore, and they legislate it out of existence, it is now illegal. In that case, the offer for the store, which consisted of the inventory of the store, would no longer be the subject of the offer, and it would be terminated. Lapse of time. Taking too long, you take too long to put in that swimming pool, it's not reasonable. Terminates. Failure of conditions specified in the offer to the satisfaction of the owner. I know you like stories, so I'm going to tell you a good one. One that won't put Shree to sleep. There was an individual on the West Coast who wanted a portrait painted of his family. He had his family sit for a famous painter who was going to paint this picture of his entire family, which he was going to hang over his fireplace in his very large and very prominent home. In the contract, it said that the painting was to be done to the satisfaction and approval of the contractor, which was the gentleman who asked for the painting to be made. So he knew that he was going to get a chance to go look at that painting before he paid for it. That was the contract. He flew to New York to look at the painting, and the artist threw the sheet back off the painting, and the old gentleman just about had a heart attack right there. It didn't look anything like his family. It didn't look like anything he'd ever seen before. And he said, "No, I will not accept this painting. This painting is no good. I will not pay you for it. I'm walking out of here now." And he left, and he flew back to California, and he had somebody else paint that portrait. Then Andy Warhol took that painting out and sold it for $6 million. It was abstract, but it was a great painting. It's hanging in some gallery someplace in Europe right now. Okay, so that was a failure of the condition to the satisfaction of the contractor. Mistake, we know what mistake is. They are erroneous beliefs regarding the contract at the time the agreement's made. Unilateral, it's made by one party. Mutual or bilateral, it's made by one and the other together. And it's usually something significant. Fraudulent or negligent misrepresentation. Fraudulent misrepresentation is the intentional, untruthful assertion of material fact. In other words, somebody really told a big lie about this thing, and it didn't work out the way it was supposed to. That way, the aggrieved party can rescind contract and sue for damages in court. Negligent misrepresentation is lesser form of fraudulent misrepresentation. Fraudulent misrepresentation, the person who makes the misrepresentation knows that it's a misrepresentation, knows that it's not legal, and knows without any doubt whatsoever that what he's doing is wrong. Negligent misrepresentation is, well, there's an accident that occurred here. We didn't mean for this to happen, but it happened. And in that case, the aggrieved party, the person who is the subject of whatever that was, who asked for that service or material, can rescind the contract and sue for damages. So negligent is accidental, fraudulent is on purpose, and innocent misrepresentation says, well, it may be wrong now, but I didn't think it was wrong when I made it. That's innocent misrepresentation, because they thought it was true at the time. It's not negligent because they didn't have any idea. Innocent misrepresentation permits the misled party to rescind the contract, and they can get the item out of their house or whatever it is that they were doing with it. But they can't sue for damages because there really aren't any if the person didn't know. The courts permit contract rescission for fraudulent misrepresentation, assuming there was a false assertion, assuming there was intent to deceive or some sort of negligence, or justifiable reliance on something that was false assertions by an innocent party. So they will allow contract rescission, not necessarily damages. Okay? Here's undue influence, and I talked about this a little bit. This is where there are persuasive efforts by some dominant party, usually someone in the immediate family. They use that special relationship to interfere with the other's free will. Okay? So free will enters into contracting a lot. Any relationship involving one party's unusual degree of trust in somebody else can give rise to undue influence. So a next-door neighbor that's been a next-door neighbor for 30 years and knows this person really well. They say, we don't think this is a good idea. Well, that can be undue influence too. But most likely it is a family member. Determinations of undue influence. Did the other party who was dominant rush the one to judgment and consent? Did the dominant party gain some sort of enrichment out of the contract? Was the dominant party isolated from other advisors at the time of the contract? And is contract unreasonable so that it overwhelmingly benefits that dominant party? I'm going to stop here for about 15 minutes and give you a break. If you want to run over and get something to eat, go right ahead and do that. I'm going to pause the camera and then come on back and we'll finish this up. I had mentioned consideration. That when we make a contract, we give something and the other person gives something. Like we pay them and they put in effort. And it has to be a legal detriment. It has to be a legal detriment to both of us. So it's something that somebody's not legally obligated to do. I'm not legally obligated to give them money. And they aren't legally obligated yet to put my driveway in. So that's legal value. It's a promise to do something that we're not legally obligated to do. The performance of something that someone is not obligated to do is also consideration. So if they perform something that they don't have to do, like they don't have to put in that driveway, that's consideration. And then not doing something the person has a legal right to do, giving up something that they're allowed to do and they have a right to do, is also consideration. I have a story about that. Back in the 1800s. I heard this story when I was in law school, and it's still true, and it's a good story. Back in the 1800s, there was an older gentleman who owned a large amount of bank money, stock, whatever, silver, that he created a bank with. And it was out in San Francisco, where most of the banking was being done at that time for the West Coast. And he had a son who had a child, and his wife was a very lovely woman from Philadelphia, and they took a stagecoach back to Philadelphia and traveled back from San Francisco to Philadelphia to visit her relatives, leaving their son at home. And by the time they went to take this trip, he was about 18 years old. So they had been out there for quite a while, and they had raised him. And as soon as they left, he kind of went nuts. You know, smoking. You know, this is in the 1800s. Now you got to put this in contrast to whatever was going on in the world back in the Victorian age. He was drinking, he was smoking, he was gambling, he was carrying on with people that were not of his, as far as his grandfather saw, social class. And so his grandfather was very uncomfortable about his whole situation. So he said, well, your parents will straighten this all out when they get home. You know, Grandpa saying, wait till your father gets home kind of situation. And so they were coming back, and by now the train ran all the way out to Carson City, Nevada, where a lot of the silver holdings were, and they could take a stagecoach from Carson City up to San Francisco. And somewhere along the way, a stagecoach had an accident, and both parents were killed. And that not only threw grandfather into an emotional cyclone, but it also meant that he was responsible for this grandson who was just out in the world doing just whatever he pleased. He was not making grandpa very happy, and he wasn't an upright, good standing citizen, and just all that kind of thing. Grandpa's saying, okay, what do I do now? I have to write my will. I have to leave this bank to somebody. What am I going to do? And he swallowed his pride, and he called the young man in. And the young man came in, and he was all disheveled, and he was just not looking like a young gentleman of that era would. And he said, look, I'm going to make a deal with you. I don't know who to leave all of my millions to in my bank. I tell you what, if you clean up your act, I'll put you in my will. But only if you clean up your act will you get my fortune and my bank. So the kid just went over and went up to the room he had upstairs in Grandpa's house, and he just sat there for a while, and he thought all about this, and he said, well, I'm going to do it. I'm going to do it. And he started out in the mailroom. He was a mail clerk. And he rose from the position of mail clerk to mail supervisor. And he was taking Grandpa to church, and he was taking his grandfather to all of these social events that he had to attend. And he went from the mail clerk to being the assistant branch manager in one of Grandpa's bank's branches. Rose from there to be the branch manager. Went back and became a vice president in charge of operations for the bank. And he just kept going up and up. And he met a very nice young lady from another San Francisco family. And he got married, had a child, and then Grandpa died. Well, he was a vice president in this bank, and Grandpa was supposed to leave his assets to him. His executor said, I'm not giving you those assets. you've never been good enough for your grandfather. And he said, I had an agreement, I had a contract with my grandfather, that if I gave up my lifestyle that I had from all those previous years that I was actually thought I was enjoying all that time, that he would give me his estate and I would be able to take over this bank and run it the way it should be run. The executor said, no, I'm not giving you a dime. I'm giving it all to charity, which meant that Mr. Executor would have been able to run the bank. And so grandson said, Mr. Executor, I'm suing you. And he took him to court. And he proved all, remember when we talked about a contract can be oral if it has all of the right elements, right? It had all of the elements, except the difficulty was that he did not think that he had consideration. And the judge heard all of the testimony and said, you had a legal right to have that life you had before. You were an adult when you were doing it. You gave it up and did everything your grandfather wanted you to do. That was consideration enough for this court. You now own this bank.
That sounds reasonable. That sounds.
It was. It was really quite reasonable. So now, most of you will recognize this bank when I tell you that their emblem was the stagecoach that his parents were killed on.
Wells Fargo.
Wells Fargo. The bank was Wells Fargo. And you ran the bank, and you see where it is today.
Horrible.
Well, we're hoping they're going to get better. They've got some problems.
Is he still alive?
Oh no, that was he died back in the
Oh, this story is old.
yes, back in the 1920s.
Oh,
Yeah, he died back in the 20s.
oh that is because Wells Fargo was the only besides Chase and I forgot the other bank, but Chase and Wells Fargo were family-owned banks.
Yes, Chase was East Coast. They were the East Coast banking power. Wells Fargo was the West Coast banking power.
Okay.
And Wells Fargo bought up all of the West Coast bank assets, all these little tiny banks in all these little towns. They bought them up and turned them into what it is now. So, consideration has to be detrimental to the promisee and beneficial to the promisor. Legal detriment is not the same thing as economic detriment. Legal detriment implies that we're giving something up at some point. But that's not the same as economic detriment, because if I make a promise and the other person returns a promise, promise versus a promise is a legal detriment, but it is not economic. Bargain for exchange, the consideration has to make the promise willing to take on the legal detriment and must be sufficient to entice the promisor to make the promise. That contrasts with something we call gifts. And I have mentioned gifts in property. And I am going to refer you back to the section on property and the video on property. Okay? Go back there and look at that and run the video, and it talks about gifts that are both inter vivos, which are given during life, and causa mortis, which are in anticipation of death. Consideration, we have some issues that we have to be careful of. One is the adequacy consideration. Is $1 enough to cover some service that we're performing for somebody else? Depends, doesn't it?
Really doubt it.
But we doubt it. Contracts that lack consideration are no consideration at all. They're not a contract because it's a prime element. And if you don't have that element, you don't have a contract. Pre-existing duties and things that involve unforeseen difficulties or rescission and new contracts all change what happens with consideration. I won't go into it because it gets long and complicated, and I'm just going to tell you that's the way it is. Read it in the book or look it up online or in the library. But I will say that past consideration is no consideration at all. If If you've done something for somebody in the past, you can't go up to them and say, well, you owe me one. No, you don't. That's not consideration, especially if it's a real contract. No, there has to be consideration now. Okay? I'm not going to touch on this. This gets really complicated, and I don't think I want to run through that. It involves liquidated debts and unliquidated debts. Accord and satisfaction doesn't really exist anymore. Unliquidated debts, creditors, in a liquidated debt, parties either dispute the fact the money is owed or dispute the money of owed. In an unliquidated debt, the creditor accepts as full payment something less than what they actually are owed. Capacity, we talked about capacity where we were talking about a state of mental competence, but contractual capacity is not the same as mental competence. Contractual capacity is the mental ability to understand the rights, duties, privileges, and responsibilities established by the contract, and how to comply with the terms of that agreement. What kind of effects do we have when we have different capacities? Well, the contract can be void. If a person does not have capacity to understand, it can be void. It can be voidable at the option of the party who is not of correct capacity, or it can be totally valid, depending on if the person did understand at the time they were making the contract what it meant. So, the valid contract satisfies all the elements. A voidable contract can be canceled at the option of one of the parties, generally the one who does not have capacity. And a contract that is void just never existed. So, contractual capacity, we say that a person over the age of 18 or majority, whichever that is in the state we're working with, are presumed to have full legal capacity to enter into binding legal contracts. Minors, however, are a little different. They can enter into a contract the same way an adult would enter into the contract, except where it's prohibited by law. There's a caveat. Isn't there always a caveat? Contracts entered into by a minor are voidable at the option of the minor. And a couple things can happen as a result. Here's what happens when we have a minor, an example of a minor who created a contract with a car dealer. An individual was 16 years old. He went into the car dealership and bought a brand new truck. He took that truck out. 2 days after he had it, a tree jumped out in front of him and he wrecked the truck.
That's unfortunate.
So he had the truck hooked up to a tow truck. He took it back to the dealership and said, I'm 16. I'm avoiding this contract. I don't want this truck anymore. It doesn't run right. Well, no, it had the whole front end smashed in. And the dealer had to take it back. This actually happened, by the way, back in Columbus, where I was practicing law at the time. Well, the state legislature got a hold of that and just shook it like a bulldog. They said, we're going to make it a law where, yeah, minors can still avoid the contract and return the object of the contract, like a truck, but they have to pay for any damages they've done to the truck. So the week after the law was signed by the governor, another young man went in and bought a truck. He was 16 too. He bought the truck, took it out, drove it around for a while. He liked it, and then a tree jumped out in front of him again. Whole front end was smashed in. He had it hooked up to a tow truck, took back to the dealership. He said, I'm a minor. I'm giving you back this truck. It doesn't run anymore. Front end was smashed in. How's it going to run? So, the dealership said, we'll take the truck back, but guess what, minor? The law says you have to pay us $4,000 to repair this truck because of the damage that you caused. So the minor had to find a way to pay that $4,000. So that's the way that minors, difficulties they have when you make a contract with someone who's under the age of majority. Now, there's another situation. I had an individual who was my client. He was, the age of majority in Ohio at that time was 21. He was 18, and he was going to college. Very responsible young man. He bought a truck, took it out, driving it around. It was just fine. He had a co-signer, which was his dad. He made the payments on his own, had a job, went to college, very responsible. And when the time came for him to turn 21, when he could avoid the truck payments and give it back and be free and clear, he wrote a letter to the car dealership and said, I am assuming the debt on this truck. I will continue to pay it. I like it. I want to keep it. The debt transferred to him now that he was over the age of 21. He continued to pay on it. He paid it off. It was his truck. So, 3 things can happen with a minor. They can avoid the contract. They can avoid the contract but pay the damages. Or they can go ahead and say, I will take the responsibility of this contract on when they turn 21. And they assume the legal responsibility. So those things can happen. All those things can happen with a minor that has a contract. Other individuals who have limited capacity to contract are those suffering from mental deficiency, and that would render them incapable of understanding the nature and obligations of the contract, and those who are intoxicated. Now, we talked about intoxicated individuals a little earlier, and they can make contracts while they're intoxicated, but it takes people around them in court to testify that they would do the same thing under the same similar circumstances under a completely sober state. And those that are suffering mental deficiency that render them incapable of understanding can make contracts as well, because everyone, even when they are disabled or unable to understand what's happening, sometimes have moments where they are so lucid that they can understand exactly what they're signing, exactly what their obligations are, and can verify that they will perform underneath those particular aspects of the contract. Disaffirmance is the power of avoidance. I just talked about this. Minors' right until a reasonable time after reaching the age of majority, they can disaffirm or avoid their contracts. To exercise the right, the minor only need demonstrate through words or actions the intent to either rescind it or to continue with the contract. And here on the slide are what they need to do in order to disaffirm the contract. So I would read those from the slide in the slide set in Canvas so that you can see what they have to do. But I can tell you positive conduct where the contract is enforced and they can take on the obligation themselves. Exceptions to the minor's right to disaffirm the contract: where a minor has a contract for necessaries. Now, necessaries are what we call necessities, but the law changes everything as far as the pronunciation goes, or so it seems sometimes. Contracts to supply minors with the basic necessities of life, they can be responsible for that. And those are things that are the very basics: food, clothing, shelter, and medical services. Ratification is the acceptance of terms of the contract after reaching the age of majority. So to ratify the contract, generally it's by a letter written to either the financial institution which holds the lien against the car, or to the car dealership that they're going to accept the responsibility. Express ratification is when they, in orally or writing, say that they intend to be bound by it, An implied ratification is when they reach the age of majority and continue to perform those actions which they did before, but now they're a legal adult. So that would almost say that that was an implied contract because they had the contract before, the contract could have been terminated, they continued to perform under the contract as it was, so it is now implied that they have ratified it. See how that works? We have these things called threads throughout the law. It's where parts of the law in other areas, like torts or crimes or Uniform Commercial Code, weave their way in through other aspects of the law. This is a tort concept. It is also a Uniform Commercial Code concept, where we're talking about implications and implied contract, okay? The general rule, where parents are concerned, where there are torts, necessaries, and contracts, is that parents are not liable for contracts that their minor children are part of, except where it has to do with food, clothing, shelter, and medical care. Sometimes education, by the way. Parents are not liable for torts committed by their minor children. And torts are the civil portion of crimes where a minor has done some damage to someone and they have to be able to obtain medical care or put back the way they were before the accident or the injury occurred. Exception, there's always an exception, a failure to properly supervise children subjects others to unreasonable risk. And where that happens, the parents can be held liable for the contract or the tort or the crime. Any minor who enters contracts for food, clothing, and shelter and disaffirms it still has to pay the value. This is why we have quasi-contract, because if they don't pay the merchant who provided the food, clothing, shelter, medical care, and education, it puts the contractor at a disadvantage because they have nothing to show for all that effort and all of those things that they did give them, which are now consumed. And so the economic disadvantage has to be made up, and so the minors have to pay for those. That's quasi-contract, which is a legal fiction. Okay? So, when can adults dump their kids?
18?
That's one way. Age them out. Age them out. Or they can emancipate them.
Yeah.
What does that mean?
Emancipation is a voluntary release by parents of parental obligations. They release all the custody and control of the child to someone else. And here's how that happens. It's most commonly achieved, let's say, military enlistment. The parent, yeah, go ahead.
Okay, so with all of those that's listed, is that automatic when those things happen? So like if I get married, then it's like, well, 18 years, but like it would have been automatic that I'm like emancipated.
No, it's not automatic. I'm going to explain how this happens. Okay. Start with military enlistment. Parent must go in with child if they're under the age of 18, so the child can enlist. The child signs the enlistment papers. That's great. He's going to be a Marine. That's great. Devil dogs are wonderful. We love them. But mom or dad has to sign on the line below them, because that says that I'm releasing my parental control to the United States Navy and the United States Marine Corps, who shall now accept control and command over my child.
That doesn't sound.
That's not strange.
That sounds weird. Like you're giving up your child to the army. Like that just. It just sounds.
That'll be for like legal reasons.
Yeah, it
because
just,
the
it's still like
army-
when you think about it, it just like,
It's
at least to
hard.
me, that like, that just sounds. kind of sketchy, but I'm sure it's practical.
Wasn't it like they did that during like the army pick, right? Because it was a point where the government actually came and picked the damn kid up themselves.
That was called conscription, and that hadn't been done since the 19th century.
You're right, because I'm saying, so then the government's come and grab me and.
They could, yeah, but now the legal rights of parents have been recognized. It's just that the child wants to do it so much that the parent is willing to release the control to the military. Now, as if we haven't punished the child enough, we're going to let them get married.
Huh? Wait, parents can sign off for that too?
Yes,
Yeah.
if they're under the age of 18. If they're under the age of 18 and two minors or a minor and B major, that was a music joke. She's the only one who got it. If a minor wants to get married and one of the couple is a minor, then the parent of the minor has to go with them to the clerk of court's office and sign off on the marriage, request for marriage license, so that they can process it, and that releases the control of the child to this other person who is going to be their spouse.
Is that present today? Like right now today?
Right now today.
If I was 17, my mom and dad can take me in,
Well, you gotta find somebody who'll have you first.
I mean, I got options, you know.
Okay, all right, if you got options, yes, but if you're 17, your mom or dad would have to go with you and sign that certificate.
So what the parents don't sign it?
Huh?
What the parents don't sign it?
And it don't happen.
So I
I
could
mean,
have
like,
married.
what about, you know how you said back in the days that they had, the parents still have to sign it. What if they didn't sign it back in the day when the government decided to take the child?
There's some confusion in here, something.
No.
Can you break that down for me a little bit more, Sheree?
I'm saying that you said.
The
that-
military and the marriage are separate.
Okay.
You don't have to, the military, they're siblings. The brother wants to go into the Marine Corps, and the daughter wants to get married. So the son takes dad to the enlistment office, and they sign the certificate of enlistment. Mom takes the daughter down to the clerk of courts, and they sign for the marriage certificate and the license. That releases, dad has released son, mom has released daughter. They can go their separate ways and become legal adults. That releases them and makes them legal adults for all purposes. And then juvenile or probate court can also, during legal adjudication, can make the child an adult for all purposes.
I'm so upset.
Okay.
I could have married a long time ago. A long time.
Go ahead, Jess, you had a question.
So the whole marrying of minors thing, would a pregnancy have any would that change anything?
No,
Okay.
no. Pregnancies are different in that when the mother goes in, especially these days, all 50 states that I know of do the same thing. When the child is born, they take down all of the information on the parent. At that point in time, the mother has the opportunity to name the father
Right.
on the form, or not name the father, as is appropriate in some cases. Okay?
Right.
So, we have this child who now has the last name of its father or takes the name of its mother. And that's how they apply for the Social Security numbers, the same way. So that's how that works. I have been through this several times.
Okay.
Because this is what my wife and I had to do when our children were married. And when we were married and when we
Right.
had them. And then I had to go through this with clients who had minors that wanted to get married. So, any other questions? I'll go.
So, in the military, policeman, so if you're like 16, is there any special treatment?
No.
Or treated like a soldier?
You're a soldier. Once you're in, you're a soldier.
You're 16.
I started training for the military informally when I was in high school. I started training for the military formally when I got into college. So when I was in high school, I was still a high school student, and the training was different. When I got into college, I was a soldier.
Was that?
I was Army. Yeah.
Then we're like ROTC, or like you just doing it?
I was a little different.
Oh,
We'll have to talk about that another time.
okay.
So, let's keep going
Yay.
to the end.
That's how to go home?
Yep.